And good afternoon. This is Justice for All, and I'm your host, George Yates. I'm glad you're with us today. We're going to be here for the next couple of hours with Joel Cohen. Joel Cohen is an experienced white-collar criminal defense lawyer from New York City, and he has just authored a book called Blindfolds Off. It's a book written about judges and how they decide their cases. I can't think of anyone really around that's more qualified to write such a book. Joel Cohen is a 40-year experienced attorney. He spent 10 years as a prosecuting attorney himself. He spent the last 30 years in private practice, and most of that in white-collar criminal defense with the Strook Law Firm in New York City. And how are you doing today, Joel?
I'm great, thank you. And yourself?
I'm doing great, and thank you so much for being on the show today. First of all, the name of the book is Blindfolds Off. Has it hit the press yet? Is it out on or is it just about to be released?
Well, it's been released by the American Bar Association, and at the moment it can be ordered in hard copy at the American Bar Association website. But based on a popular consensus that it should be more available to the general public, it is now available for pre-order on Amazon and BarnesandNoble.com, and I assume they'll be available to be purchased and actually received within the next week or two.
When I read your book and then I read your resume, I thought, well, you're really well qualified to do interviews with these judges because of your background. I see that you serve on a judicial panel. You're a member of the New York State Commission on Judicial Conduct since 2010, and your white-collar criminal practice says that you've actually defended. You defend lawyers, you represent lawyers in various kinds of proceedings, and you've represented judges as well. So you have some experience both in your practice with judges beyond just this book.
I suppose that's true. I guess it's important when you're writing a book to have that kind of background, although I have to say that I probably learned an awful lot about the judiciary that I had no knowledge of until I started interviewing these folks who I interviewed for the book.
Well, let's get started then with this book because there's those of us, both lawyers and litigants, anybody that walks into a courtroom, they see this person, this usually a man, but now more women, and they're up there sitting higher than we are, and they're dressed in these black robes, and it's a scary place. For those of us that have been practicing law for many years, it's less scary, but still, it's such an imposing figure, these judges. And your book tries to pull away this veil of secrecy around judging. So what exactly, my first question to you is, how did you make your choices of these particular judges? And I have several questions really to follow. You chose just federal judges, it looks like. There were 13 federal judges, and you chose them from all over the country. So tell me a little bit about, I know it's a multiple question, but how did you go about choosing the judges? How did you go about finding them for your book?
Well, it's sort of interesting. I originally I had intended to write the book with Judge Rakoff, who is a very well-known district judge in New York, and we had actually thought about working on a book together where I would interview him on 10 cases, and he's had really big cases over the course of the years, and obviously we'll talk about them during the next hour or two. But it became apparent after a while that he was so busy and industrious as a judge. The guy is a workaholic, and it was just impossible to even schedule times to spend the hour and a half or so necessary to interview him. And he, after a while, started feeling guilty about it and said, you know what you ought to do is you ought to try to change this book to get judges from around, whether it was in New York City or around the country, on big cases of theirs and make them into a compendium, which I decided to do. And my first stop after the interview with Judge Rakoff over the death penalty that he had declared unconstitutional many years ago, and it was later reversed by the United States Court of Appeals in New York, my first stop was to Judge Weinstein. And Judge Weinstein is literally the dean of the federal judiciary. He's about now 93 years old, and he was a giant even when I was a prosecutor in that district where he sits in Brooklyn, New York. And I figured if I'm not going to get him, I'm not getting the cream of the crop. So I immediately contacted him, and I knew him vaguely. I had tried cases in front of him years before, but I didn't know him personally. And he agreed to do it. And frankly, I was intimidated by the prospect of interviewing Judge Weinstein. He doesn't suffer fools gladly, and I was afraid I'd fit into that condition with him. So what I started to do is try to pretty much cold call other judges, cold call by letter, other judges from around the country, saying what the nature of the book was, and that I had Judge Rakoff already interviewed, and Judge Weinstein agreeing to be interviewed. And several judges from around the country literally said to me, if you have Rakoff and you have Weinstein, how do I say no to you? And these were people I don't know. So there were a couple other judges in New York whom I did know, and they pretty readily agreed. Judge Chin sat on, he's now on the Court of Appeals, but he sat on the sentencing of Bernie Madoff, and I wanted to interview him about that. And I had agreed, had Judge Alvin Hellerstein, who's a former law partner of mine, who sat on the 9/11 civil cases in New York. I thought that was a big component of the book. And I would actually be in social situations with friends at the bar, sometimes in a bar, but friends at the bar, who said, well, you know what? Judge Kuczynski in the Ninth Circuit has written an opinion in which he literally says that most federal judges suffer from unself-conscious cultural elitism, basically meaning they can't relate to poor people and don't treat them as well in their opinions as they might treat people who are their economic peers. I pretty much cold called him with a letter, and he agreed to do it pretty quickly. Somebody mentioned to me, well, you know, Judge Walker in San Francisco, he's retired from the bench, but he decided the same-sex marriage case, and after he retired from the bench, he acknowledged publicly that he was gay. That's got to be an interesting interview. Some friend of mine who practices law in Chicago told me that Judge Kokoris, whom I didn't know or know of before, had held in a class action lawsuit that a Nobel Prize winner in economics was not worthy of belief. He was not credible. That takes quite a bit of guts, frankly, by a federal judge to be making that kind of a decision. I basically had a friend who knew him call him for me. He agreed to, and so on and so forth. And that's it's sort of, they were sort of self-selecting. My colleague Dale Degenscheid, who has worked with me very importantly on this book, she saw a decision in a case by a Judge Jones in Harrisburg, Pennsylvania before. He basically decided an intelligent design case against those folks who wanted to teach intelligent design in the public schools near Harrisburg, and I cold called him, and he said fine, and I literally went down and interviewed him a week later. So it was sort of that kind of a self-selecting process, but usually with cases that were a big deal, and most people around the country know about those cases because of the importance of them to the body of law in the United States.
Well, you've got a varied experience. You were a prosecutor in the organized crime unit, the prosecutor's office in New York City. You've been a litigator for 30 years with a top firm. I would guess that somewhere along the way you've been considered for a judgeship or have served as a substitute judge somewhere along the way. Have you ever been considered for a judgeship or thought about a judgeship for yourself?
People have mentioned it to me over the course of years, but I'm a very moody guy, and that would not be so good for the litigants. If I got up on the wrong side of bed that day and were sitting on the bench, people could go to jail that don't deserve to go to jail. I say that somewhat glibly, but the real reason why I've never really wanted to be a judge is sort of like you probably have played baseball in your life or basketball. You'd rather play the game than referee the game. I think there's more action, at least for me and my personality, in being a litigator rather than being a referee or an umpire.
Right. Well, that's kind of how I read your resume as one of such a varied litigation experience, and you're uniquely qualified to interview these judges. If you were a judge, which one of these 13 that you interviewed, and I'll go up by, you've mentioned many of them by name already, and it is an interesting list of people, and you chose some fascinating characters. But which of the 13 did you find that if you were to be a judge that you would be the most like? Is that a trick question?
Not a trick question. It's a tough question because there's some pretty able judges. I admire Jack Weinstein, who I said before is the dean of the federal judiciary, and I come to admire him more from this process than before. He was extremely well known. He's literally been on the bench for 45 years. He was extremely well known in my day as a prosecutor as being this gifted scholar on the criminal law, and he's literally written the book on evidence. The book Weinstein on Evidence is the leading treatise on evidence in the United States. I believe still so. But what I learned from interviewing him about the Agent Orange case, he presided over the Agent Orange case, is how gifted he has been in terms of a whole area that I didn't know about, and that is in the civil practice. He's also written a major book on civil practice in New York. How much he brings to the table, I can't say I would be like him. I would aspire to be like him because of the gifts that he has. But closer to me, and he's closer to me in age, and although much better educated than I am, is Judge Rakoff, who sits in the Southern District of New York. He's extraordinarily gifted, not nearly as old as Judge Weinstein and not nearly as tenured as Judge Weinstein, but he has done some phenomenal things in making the bench and the bar, the public, and the journalism profession look at the law in ways that they really haven't before. I mean, he's constantly thinking outside of the box and has made the most of his judicial career. And like I said, he's better educated than me, far smarter than I am, but he's a guy I would aspire to be like.
Well, and you had actually tried some cases in front of these judges, practicing law in New York. Which judges had you tried cases in front of?
Of the ones in New York, the ones I've tried cases are in front of are Weinstein. The others actually, one was my law partner, so obviously I never tried a case before him. But the other two are probably my age or younger, so they weren't on the bench yet, so that I could have tried a case before them.
Why did you choose federal judges? Is your practice only in federal court? Did you make that determination, or did you ever think, well, maybe I'll interview a state court judge or a state Supreme Court judge or maybe even a municipal court or traffic court judge, just to kind of see the various thought processes that go into the different types of jurisdictional disputes?
That's a great question, and a question probably I hadn't thought about as much as I should have when I was putting together the list of judges. The large reason why I didn't pick state judges is because I was looking for really big deal cases around the country that the members of the bar or public would actually know about. So it's more likely that a case of federal dimension would be known to the public around the country. But as a friend of mine who's a good friend of mine and made a valid criticism of the book is, why didn't you choose state judges? Because state judges are subject to different pulls and strains on them that federal judges aren't. I mean, after all, judges have life tenure unless they screw up horribly badly or commit a crime. They're literally going to be on the bench for life, and they could write any opinion that they want, and they might get reversed on appeal in the Court of Appeals, or they might get reversed in the Supreme Court of the United States, but otherwise, there's not much you could do to a federal judge because you don't like his opinion. That won't be the case often in state judges if the judge has gone way off the rails in deciding a case. And because they have those strains, and more recently in the case of some judges, the chief judge of California, her name was Elizabeth Byrd. Years ago, she was literally recalled from the bench, as I recall it, because of some of her opinions. And other judges have suffered the same fate in Iowa. There were the Supreme Court, the Chief Justice of the Supreme Court of Iowa was literally recalled off of the bench because she decided in favor of same-sex marriage. And she knew going into deciding the case that they would vote to recall her, and she felt it inappropriate for her to fight against the recall vote and basically got removed from the bench. That kind of problem doesn't face federal judges. And so, basically, I did not consider that in terms of my interviews because it frankly didn't affect those judges. But it's a valid criticism, and if I would ever write a follow-up book like this one, I would do it about state judges.
Right, because just the other day I was trying a case in front of a local traffic court judge. I mean, I'm in traffic court and criminal court and federal court, and I'm all over the place. Trying to defend a DUI case anymore is very difficult to get a judge to give you a break on one. And the judges will sometimes make no bones about it. They'll say to the lawyer, well, I'm not going to lose my job over this case, and rule against the defendant. I'm wondering if they have life tenure, if they're not going to not be so afraid to maybe rule in another way. I was interviewing a DUI lawyer from Boston the other day, Stephen Jones. He's the dean of the National College of DUI Defense, and he said in Massachusetts those judges do have life tenure and does make them a little bit more inclined to rule, in favor of the little guy. And my question then kind of segues into this, Joel, is do you find then that these federal judges, because they have life tenure, maybe can rule in favor of the little guy a little bit more because they're not as afraid of removal?
Well, obviously, it depends on the judge in question, but yeah, I do think that they're more free. It's sort of interesting. I also generally picked judges that were older in terms of the judges that I was selecting to do the interviews with, on the theory that they were more tenured, more confident in themselves, not worried by second guesses, perhaps in the editorials of the local tabloids and whatnot. So they were willing to basically say what was on their mind in doing things that were on their mind in terms of what they thought was a righteous judgment in a case. But yeah, I do think federal judges, and it certainly was true in the civil rights era. The guys in the South, like Frank Johnson in Alabama, who was a giant in terms of civil rights, John Minor Wisdom in New Orleans, those guys, as federal judges, we can all hope that they would have done the same thing as state judges, but as federal judges, it was so much easier to do the right thing for the little guy. No question about it. You're right.
And yet there's some recent books out now, as I'm looking through my guest list of people to have on the show. We find that, and I don't know what your opinion is on the current Supreme Court of the United States, but so often it seems that the Supreme Court of the United States, they also, of course, federal judges have life tenure. So many of their decisions of the Roberts Court in the last few years have been in favor of corporations and government, and it seems throughout the history of the United States Supreme Court, it seems that the rulings have been in favor of corporate interests and the government interests. And I noticed, so it just seemed that these judges that you profiled, several of them were not afraid to rule in favor of those that were less fortunate, because they realized that as judges it was their duty to protect the less powerful against the most powerful. But I wanted to ask you another kind of a question, since we've talked about you talked about some previous judges in history. If, as you were looking through people to interview, if you could interview any judges in history, who would you have chosen? I noticed you talk about Cardozo in the book. He's quoted throughout the book as, who is Benjamin Cardozo, and would it have been great to have interviewed him for your book?
Yeah, well, Benjamin Cardozo was probably the leading light on what lawyers refer to as the common law, that is, case law in the United States. He was originally on and chief judge of the New York Court of Appeals in New York. That's the highest court in New York, and he was known not only for his wisdom in terms of decision making, but he had these unique phrases that he would use that would really capture the essence of what he wanted to say. And he was literally a genius in terms of his writing ability, and he ultimately was then nominated to the Supreme Court of the United States, where he sat. But he wrote a book called The Nature of the Judicial Process, which basically first-year law students are at least asked to read. I don't know if they all read it. And it was kind of turgid for me when I was a law student, but now I see the genius of it. And he literally said in the book, in his book, and I repeated it in my book, and I sort of dedicate this book to him, that the tides and currents that pass the rest of mankind don't slip around and not confront judges as well. The same currents that face the rest of man confront judges as well. And what he was basically saying is the kind of, I use the word baggage, although I don't mean baggage in a negative way, the kind of baggage that most people bring to all decision making is basically the kind of thing that comes to judges. If a judge comes from a poor community and he's brought up having to deal with being basically the low man on the totem pole, that may affect his judging because that has affected his life. It's kind of an interesting fact that when I went to law school in New York, I went to NYU Law School. I had heard that Cardozo, who was long deceased at the time, had attended with his family a synagogue, which is a very old synagogue in New York City, and young law students were sort of in love with Cardozo, and I literally went to the synagogue and asked the caretaker there to show me where the Cardozo family sat when they would come to pray, figuring maybe I'd get some inspiration from that location. And I never was able to find out the exact seat, and obviously never got the inspiration that I should have gotten. But I've hoped by dedicating this book to him, I've somehow made up for that.
If you've just joined us, I'm here with Joel Cohen. He's a litigator from New York City. He's just authored a great book called Blindfolds Off, Judges on How They Decide. And this is Justice for All. I'm your host, George Yates. We have just a few more minutes before the break. You quote Cardozo saying, the life of the law has not been logic. It has been experience. And I think that was the course of this book, right? It was you were, and we'll get to this a little bit after the break, but what was the overall purpose of this book here, if you're going to boil it down to just one sentence or two, as to what you were really trying to do in these series of interviews?
I think basically the public believes, certainly the non-lawyer public believes, that judges come onto the bench or try to come onto the bench to be as objective as possible in all their dealings as a judge. I think what Cardozo said, and I think what is basically said through these interviews, is that it can't possibly be that way, that judges are human beings and they bring a human dimension to it. Some of these judges are more guarded in terms of coming to terms with the fact that they can't be completely objective, some less so, some not guarded at all. And some are willing to say that total objectivity on the part of a judge is a ludicrous concept, and the public should stop believing that. It can't possibly be that way. We should be objective in terms of the rule that we make, that we should honor what the law says and apply the law to the facts, but there's too much in the play in the joints to just conclude that a judge is totally objective. We frankly don't want robots or automatons to be making decisions that so affect society.
This is Justice for All. I'm your host, George Yates. We're here with Joel Cohen. When we come back, I'm going to ask Joel which of the judges he interviewed he thought were the most candid and honest with him about why and how they make their decisions. And we're going to ask him which ones were the most guarded and maybe the less forthcoming as to their motivations in deciding cases. We'll be right back with Justice for All after this message.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
We are back. This is Justice for All. I'm George Yates, and our guest today is Joel Cohen. He's recently authored the book Blindfolds Off, and a book about how judges decide cases. And as I was reading through your book, you start off your book. Richard Posner, the great appellate judge from Chicago, writes about how the problem with being a judge is that most people do not know themselves as well as they think they know themselves. Is that was to some extent the focus of your book, wasn't it? Was trying to determine whether or not these judges could get outside of themselves and be objective in deciding cases?
I think there's some of that to it. It's hard to say whether they didn't know it before the interview. I think some of them, one in particular, I remember, who goes nameless, literally said to me after looking over the transcript of his interview, "I can't believe you got me to say that." But I guess that's what a good interview is supposed to be. I don't tell that story in order to pat myself on the back, but I think maybe I was asking him to think about something in a way that maybe he had never been asked to or asked himself to do.
Which judge was that?
Yeah.
Which judge was
Pardon
that?
me?
Which judge was that surprised himself in how candid he was?
Well, I don't think he's
Okay.
mine. It was Judge Jones. He sits in Harrisburg, Pennsylvania. Has now become a friend of mine as a result of this process.
Well, I would imagine that you became close to them. Judge Jones was the one that decided that intelligent design case,
Yes.
which was fascinating. You tried to get him. I'm just going to ask you generally. You tried to get these judges, and were sometimes successful. You tried to get these judges to admit many times that they had already prejudged a case before they'd heard it, and they always refused to go there. And that was the one thing. And the second thing that kind of was interesting to me, and I don't know if this surprised you also, but none of these sitting trial court judges, I'm talking the district court judges, ever said that they consulted or conferred with other judges decisions in these cases. Didn't that surprise you?
Actually, there is an exception to that. I know that Judge Rakoff, when he declared the death penalty unconstitutional,
okay, you're right,
did tell me that he spoke with Judge Sand, who's a more senior and very well-regarded judge in the Southern District of New York, who had a death penalty case. He did say he conferred with them. But by the same token, Judge Rakoff said when I asked him about whether he participated in bull sessions or the like in the judge's lunchroom about cases, he said he would generally not offer his opinion to other judges who sort of asked around the table, well, what would you guys do in this instance? And he said he was concerned that he would often be in situations where he was asked that, and he didn't feel comfortable giving his opinion because sometimes he didn't know all the facts, or maybe he might not have received, not because the judge was not being candid with him, but he wasn't getting the full nuance of what he was being asked and didn't want to offer his opinion that might somehow impact the decision-making, and he didn't have all the facts before him.
Yeah, I stand corrected. I do recall now. Rakoff did, and he said that when he spoke with the other judge that agreed with his position, that did steal his nerve a little bit, because he made the unprecedented decision to declare something unconstitutional before he even heard the case.
That's right.
And that was pretty bold. And then, of course, they sent the case back to him for trial, right? That was a death penalty case, right?
Yeah.
But
and ultimately, he had declared the death penalty unconstitutional. The Court of Appeals sent it back and said it's not unconstitutional. Proceed with the trial. He proceeded with the trial. In federal court, the death penalty is decided on not by the judge, but by the jury, and it has to be unanimously. And the jury was not unanimous in that regard, and therefore he imposed life imprisonment in the case.
When did it surprise you? Because I know when I think a lot of people might think this, but certainly a lot of lawyers might think this. You're in court, you're trying a case, and then the judge takes off and goes back into his chambers. And I think that in the past we might have thought that this judge might just be walking down the hall and chatting with his law clerk and maybe going down and bouncing it off of another judge in the other office who might be not be off that day. And every one of these judges, with the exception of Rakoff, said that's just not part of the culture. And several judges made that same comment. And what struck me, Joel, was that you did interview some appellate court judges, judges that decide they're above the district court level, and it's completely the opposite with them. They take great pride in trying to convince other judges of their position, and if the other judges don't agree with their position, they take great pride in these vigorous dissents. Didn't you see there was quite a difference between those two positions? The district court judges never consult, and the appellate court judges are always consulting.
No, that's true, and they necessarily have to. What I always found sort of interesting about the Supreme Court of the United States is when Justice Rehnquist was an associate justice, he was sort of out there on his own. He wanted to write it. It seemed to me he wanted to write his opinion and not really convince others, because if his language was more toned down, he might convince others to join his opinion. My sense of it is he didn't frankly care to accomplish that, although it seemed to me that he would change, and I think he did change when he became the Chief Justice, because he felt a greater obligation to build a consensus. Justice Scalia, on the other hand, it seems to me he really doesn't care. He wants to say something, and he says it very articulately and often very stridently, but I don't think he really cares about convincing others to agree with his position. He wants to take a certain academic position or political position, as it were, and not necessarily get others to come on board.
As a practical matter, how much time did you prepare for these interviews with these judges? I know I spent quite a bit of time preparing for my interview today with you. For instance, I read your book and so on, and spent several hours getting ready today. With each of these judges, what was your preparation and what did it involve?
It actually wasn't that much, because most of the cases I was reviewing with them didn't require me to read a trial record. I read the relevant decisions that the judge wrote, or if there was an appellate decision from what he or she did, I'd read those. In some cases, I might read some transcripts, but I'd also want to know something about the judge and read up on their biographical material and whatnot. But the interviews themselves, and it was sort of easier to write this book than it would be to write a book in which I was basically interviewing people and talking about those interviews. The interviews themselves lasted no more than an hour and a half, and they were all transcribed. There was a tape recorder on the judge's desk, and it would be a give and take. It would sometimes, in Judge Weinstein's case, he speaks very fast and very directly with no nuance, and I don't mean that in a bad way. He's very clear on what he wants to say, and his interview was probably less. It probably only took an hour, but the interviews themselves would usually take an hour and a half. And I'd have my assistant transcribe them, send them, make changes all for style, not for substance, send them back to the judge. And what's interesting about it, all the judges were given carte blanche to review and remove anything that they wanted to. If they wanted to take out my questions and their answers, or take out their answers or some part of their answer, they were free to do that, or to change it in any way they liked, substantively. And none of them did that. There were a few nits here or there that they changed, But all of them basically stuck to that's what I had to say, and that's what I meant, and I'm comfortable with it. And that was kind of remarkable because some of them did say some stuff that's pretty much out there.
As far as the judges that you've discussed, I think the first one in your book that you discuss is Leonie Brinkema.
Leonie Brinkema.
And she, that's right here in Virginia, up in Northern Virginia. She tried the Moussaoui case.
Correct.
Fascinating account of the Moussaoui case. What did you take away from that interview with her?
It was sort of interesting. I mean, she sat on a case which basically was conceptually known in the public as the trial of the 20th hijacker. There was a view that he had started out intending to be one of the 20 hijackers involved in 9/11. And she concluded that he grossly overstated his role in the case, that the government couldn't prove that he was the 20th hijacker in that sense, but that he had engaged in a conspiracy to blow up buildings in the United States. And she seemed to, it's hard to use this word when you're talking about 9/11, but she seemed somewhat amused by him, that he was very intelligent, that he knew the case better than his lawyers. And she was somewhat astonished and pleased by the fact that he ultimately pled guilty, and he ultimately wanted to withdraw his plea. And he said, the reason why I pled guilty was my concern was that I couldn't get a fair trial in the United States, particularly in Alexandria, Virginia, and I was wrong. The justice system and Judge Brinkema and I suspect a jury would have treated me fairly, and therefore I want to take a shot at it and go to trial. She was she felt I in some way complimented, or the American system was complimented by what he had to say, although she didn't give him his guilty plea back. But she felt that if it was her decision to sentence him, she wouldn't sentence him to a maximum of life imprisonment because she thought a sentence of, I forget what she said, 20, 25 years would probably be sufficient under the circumstances of the case, which was shocking for me to hear, as it was shocking for me to hear from her just her general sense of the fact that all defendants, and of course it's true, need to be treated with fairness and decorum in the case, and that she would be able to strip away from her consideration in deciding motions in the case the fact of this guy's crime was as any crime one conceive of in the 20th or 21st century, and she treated him as such, and I believe her, actually. It's hard to believe judges sometimes when they say this kind of thing. You almost take it as this is judicial pablum. They sort of feel forced to say this kind of stuff about their experience as judges. I totally believed her that she felt I could look at this defendant as I could look at any other defendant and give him a fair shake in my courtroom.
If you've just joined us, this is Justice for All, and I'm George Yates. We're here with Joel Cohen, who's just written the book Blindfolds Off, Judges on How They Decide. And on this Moussaoui case, I was shocked, too, because it seemed that you were basically got her to admit that had this case gone to trial, had Moussaoui not pled guilty, she might have found him not guilty, certainly on some of the counts. And she felt that he overstated his role in the whole 9/11 thing, and that the government really had gone after the original concept as him being the 20th hijacker wasn't true. Did you get the impression from her that she may have found him not guilty on the charges had he gone to trial?
That wasn't my sense that she would find him not guilty, but she certainly would have problems with the case, and she was clearly not sitting there fuming, but she was angry at the government because she thought that the government made serious mistakes in terms of prosecuting the case and discovery materials relating to it and whether they were making witnesses available that they should have. She was angry, not angry enough to throw out the case, but she
close.
did give...
She almost threw it out. It looked like she was thinking about
she was going to throw out she was going to throw out the death penalty at least. But
right.
She it's sort of interesting. She is a very pleasant woman and is very careful with the words that she expressed during the interview, and she doesn't give the sense of somebody who is presenting herself as a judge who's sitting on a higher level than the rest of the people in the courtroom. She presented herself as the peer of the folks in the courtroom, including the peer of the guy who she was going to have to decide his fate.
Yeah, and of course that brings up the larger question about the KSM trial that is not going to be held in federal court, and it's going to be tried in, I guess, in Guantanamo.
Right.
And she certainly. I basically, from what she's saying, and I've gotten that from several guests. I had Jim Ziron on my show a couple of months ago, and he felt the same thing. You know, anybody that's a veteran federal prosecutor and judge and litigator thinks that certainly these terrorists could get a fair trial in the federal courts. What do you think?
I agree with him, and basically pretty much anybody who is a federal judge or a litigator who practices in the federal courts will probably come to the same conclusion that both the defense and the government will get a fair shake in the federal court, and it's ultimately better for society because it basically makes the proceedings transparent. You and I have no idea what goes on in Guantanamo and what is kept from the parties. In a federal court, it's open and presumably above board, and we really get to know whether justice is really being dispensed in that courtroom. We don't know about it in Guantanamo.
You interviewed Judge Denny Chin, who sentenced Bernie Madoff. What did you take away from his interview?
Judge
150
Chin,
years, I guess, is the as I read it, Joel. It seemed that the whole purpose of that 150 years, and you talked a lot about retribution and revenge. The word was used a lot, and we don't use revenge a lot when we're talking about the federal sentencing guidelines, or when we're talking about 3553. We use the word retribution, but the word revenge got used a lot by Judge Chin.
Well, actually, he was not so comfortable with the word revenge. I was probably trying to shove that down his throat a little bit. He's not comfortable with that phrase. Judge Chin is also very cautious in his words, and I thought all the judges, frankly, were being truthful with me. But I'd say he was somewhat guarded in it. I asked him, for example, instead of giving the guy 150 years, he was already 70 years old. He's not going to live past 100 at best. Why don't you just give him 40 years? That'll accomplish the same thing. What are you trying to do with 150 years? And why don't you instead say, look, Mr. Madoff, excuse me, my purpose is to make sure that you never see the light of day. Why didn't you say that? Isn't that what you were trying to accomplish? Make sure that he never saw the light of day? And he said, you know what, I don't use phrases like that. There are some judges who, as a matter of style, might say that, but that's not my mentality. That's not who I am as a judge. By the way, I think that more often happens in state court than in federal court generally. But he was basically saying, it's a matter of style. This is my style. Whether you want to call it revenge or whether you want to call it retribution, those are different concepts. They probably mean the same thing. I'm just not comfortable saying the word revenge. And I tried several times to say, what's the difference, even citing to a friend of mine who wrote a book about the need for revenge in the American courts. And he says, I've had that debate with that guy also, but maybe that's him, that's not me.
Yeah, and I think that throughout the sentencing of Bernie Madoff, there was very little that Judge Chin could find to mitigate his sentence. There was very little remorse on the part of Madoff, and it was just Madoff. I'm sorry, and he just He couldn't find anything to redeem Madoff at all. So when he came up with 150 years, he went back. He states in his interview with you that sometimes you have to give a defendant hope. And I made a note of that when I read your book. Sometimes you have to give a defendant hope. And he wanted to slam the door on all hope for Bernie Madoff, and he wanted to make sure that all of his victims knew that as well, it seemed to me.
I think that's right. I mean, what he did is he made the courtroom available for all the victims to appear or write letters or say what they wanted to say. He thought I guess he thought part of the expiation that these victims required was, for lack of a better word, their day in court, and he was going to give it to them. He didn't have everybody speak because that would have frankly made the courtroom into a zoo. But he wanted to give them the opportunity to say what was on their mind. He gave them the opportunity. Nobody among the victims, I suppose he felt, could quarrel with a 150-year sentence. So he was basically making a statement that seems a little hackneyed, but this is the crime of the century in terms of white-collar crime, in terms of the people that were affected. And I feel it's appropriate to give him that sentence. And it's not a sentence that could be reversed, and Judge Chin felt that's what he thought the right thing was to do.
I was struck.
He also went out of his way to say he had not made up his mind to do that, as soon as the case came before me. In other words, when the case came before him, Madoff basically pled to the whole case. You would think at that point a judge says, well, this guy is never going to leave jail if I'm the judge in the case. But Chin went out of his way to say, I had not made up my mind until I read the pre-sentence report and saw all the evidence that existed, pro or con.
I was struck that Bernie Madoff wasn't even able to provide any letters from anybody. No one even wrote a nice letter on his behalf at his sentence.
Yeah. I think he probably could have gotten a couple of letters, and I think his lawyer probably concluded they would look so, anemic next to what was being said about him that it was probably a better idea to do nothing.
Right. As far as, and once again, I think Chin was the one that had also said it's not part of his culture. He never consulted with another judge, which is pretty consistent.
That sounds absolutely right in his case, actually. It seems to me he's, not in a bad way, but he's a loner. He makes his decisions by himself. It's sort of interesting. When I came to his chambers, I had never been in his chambers before. He sat in the chambers where Thurgood Marshall, later of the Supreme Court, sat. Thurgood Marshall was a judge of the United States Court of Appeals of the Second Circuit that Judge Chin sits on now. He was extremely proud of that he was the judge sitting in Thurgood Marshall's chambers. I'm sure in terms of Thurgood Marshall's role in defending and helping the little guy, that probably is something that favorably weighs on Judge Chin every day.
You also interviewed Martin Feldman, and I think that it seemed like throughout that interview we kept hearing the name John Minor Wisdom. Who was Judge Wisdom?
Judge Wisdom in the, I guess, 60s, 70s, and thereabout was, and maybe later, was, it's a great name, John Minor Wisdom, but he was a great judge who sat in New Orleans on the United States Court of Appeals, and he was very well known for deciding major civil rights cases during the civil rights era. And Judge Feldman, whom I didn't know before, had been Judge Wisdom's clerk. And in the interview of Judge Feldman, we talked about his having, what had happened is, after the BP oil spill off the shore of Louisiana and Mississippi, the government wanted to impose a moratorium on offshore drilling as a result of the catastrophe of the BP oil spill, fire and explosion and spill. And the case came before Judge Feldman by random selection process, and the government wanted a moratorium of 6 months. And Judge Feldman was opposed to the moratorium in his decision, and he felt that the government was not being completely candid with him in its litigation posture in the case.
Well, they really didn't present any really good evidence to support why why there should be a moratorium, other than the fact that.
Well, but beyond that, he thought they were misleading.
Right.
And I said, Judge, let me ask you a question. Basically, you don't know me, but if I were a judge in the case, I would be concerned that there might be another explosion if you don't impose the moratorium, and then your obituary will be you denied the moratorium, the result of which is a similar act that lightning had struck twice. And he said, and I think he was choosing his words carefully because he might have said it differently, I don't give a damn what my obituary says about that, and I don't care what the press says about it, and I don't care what the Rotary Club around the corner from me says. My job is to call him as I see him, and I thought that the government had not proven its case, and that's it. And I'm not going to allow a moratorium where it shouldn't be imposed.
Yeah, and that was an amazing. Did you feel that maybe Martin Feldman, the judge in this case, did you find that maybe that's a little bit out of step with what a judge really should, what the kinds of things he should consider? I mean, it just seems that if you don't care what anybody thinks, you don't care what your friends think, you don't care what the people at the club think, it makes you, it doesn't, I mean, to be that sure of yourself, to not care what anybody thinks, it almost as if you better be right or you might well be out of step. So, especially when you...
Well, I think he knew that if he was so out of step, the Court of Appeals would alter his decision or reverse his decision. So it wasn't that he didn't care. He said, if the Court of Appeals reverses me, I'm going to do what the Court of Appeals tells me to do. Mm-hmm. So it wasn't like he was the final law on the subject. There was going to be somebody else who would take a look at it. It would be three judges who would take a look at it. I think what he was saying is, I'm independent, and I have to be independent, and that's my job, and I was nominated by the United States Senate, nominated by the President of the United States and confirmed by the United States Senate, and they had the confidence in me to do this job, and my job is supposed to be carried out independently. It may be that he was a little bit cavalier in his language about it, but in many respects, I think you want a judge who's not... That's why we give life tenure to judges, because we want them to be, in some respects, unyielding in terms of what they think the law should be,
right?
How it should be applied.
Well, it was definitely a refreshing toughness from. I mean, you read the interview with him and you get it all the way through, and he says that this is what he learned from John Minor Wisdom 50 years ago, and he's just passing it on. So apparently, and
as an example, just a few weeks ago, Judge Feldman is the only district judge in the United States who has held against same-sex marriage. All the other judges whom the issue has come before in the last 2 or 3 years have ruled the other way, and he said, basically, as he said to me in that interview, I don't give a damn. This is what I think the law is or should be, and that's my decision in the case. And if the courts of appeal reverse me, then I'll get reversed.
And as you said to him, no one, sir, will ever challenge your directness. That's how you ended the interview with him.
I do remember saying that. Yeah.
So I think you were...
I guess I'm a little more strident in the comments I make now because I'm getting older. If I were conducting that interview 20 years ago, I never would have said that.
Well, I think that after that interview, it was pretty clear that he was... He was somebody that was not going to budge from his position, and no matter how hard you tried. And I noticed that was true with many of these judges. You were tenacious, and you're trying to get them to change their position, and they stuck to their guns. So that was really actually pretty... I
remember after I turned off the tape, he said, "I didn't use any dirty language, did I?" I said, "No, Judge, don't worry about it."
Oh, well, that means good. That means that you got them really talking without even thinking. We're here with Joel Cohen. This is Justice for All, and I'm George Yates. We're going to take a little break here, and we'll be right back after these messages. We're going to be back with another hour with Joel Cohen, is the author of Blindfolds Off, Judges on How They Decide. We'll be right back.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their two locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
All right, we're back. This is Justice for All. I'm your host, George Yates, and we're here with Joel Cohen, who has written a great book, Blindfolds Off, Judges on How They Decide. And Joel is a litigator in New York City with 40 years of experience, both as a prosecutor for 10 years and now as a white-collar criminal defense attorney for the last 30. He's uniquely qualified to interview and discuss judges and judging with these judges. He's written this book called Blindfolds Off, and he chose as his subjects 13 federal judges who were involved in some very high-profile cases, all the way from the Moussaoui terrorist trial to the sentencing of Bernie Madoff and the intelligent design cases, gay marriage. Joel, you picked some really interesting topics. I know we talked earlier how you chose these judges, and then you went, and in my opinion, and this is just a really fascinating chapter here on Judge Nancy Gertner, because I think that organized crime is pretty sexy. Murder is always, gangs and murder for hire and all this kind of gets the news probably more than a oil spill case or anything else. And Nancy Gertner presided over a fascinating case where the FBI was accused of framing some men for murder. And the case went all the way up to J. Edgar Hoover. Tell us about Judge Nancy Gertner and the case that she presided over. It's probably the most interesting chapter in your book.
Well, actually, the truth of the matter is that I had not intended to interview Judge Gertner. I had completed the 12 interviews. I had started off with the idea of doing 10, and it came up to 12, and I was basically closed out. And frankly, what authors are required to do is get blurbs for their book. So somebody mentioned her to me, or there was an article in the paper that mentioned something that she said about judging. She was already retired from the bench and back at Harvard Law School. And I called her up through an introduction from a mutual friend, to ask her about looking at the book and maybe writing a blurb. And she said to me, tell me about the book, and I did. And said, how many women do you have? And at the time, I only had one woman. And she says, Joel, how do you explain that you only have one woman judge? So I sort of got a taste of Judge Gertner right away. And she said that she'd be interested in talking with me on an interview basis, and was interested in talking about that case. And I said, actually, I was originally looking for a Southern woman judge in order to round out a demographic in the book. And she said to me, Joel, I can speak in a Southern drawl if you like. And then I knew I had somebody that I had to interview. And like I said, I was getting close to getting it to my publisher, and we agreed to meet on the campus of Harvard Law School a couple of weeks later. And she said that case would be one she would like to talk about. And she's actually writing a book on judging herself as we speak.
Well, she's a fascinating character, both a cheerleader and a valedictorian of her of her high school class. That you don't hear about that every day. And of course, her husband is the director of the American Civil Liberties Union. I mean, she's just she has a very interesting resume. Tell us about the case she presided over.
Well, she sat on a case after this great Whitey Bulger scandal emerged, where Bulger was a mafia guy in Boston, had been in league with some corrupt FBI personnel, and as part of his cooperation with the FBI, it led in the direction of a couple of guys who were on the fringe of the mafia actually being framed for a murder that apparently they didn't commit. And there was efforts made. It was a state murder case, and what had happened is that the FBI helped to suborn testimony, or particular agents in the FBI suborn testimony, leading to the conviction of these guys who spent a lot of time in jail. Ultimately, they were exonerated, and they or their estates, in the case of those no longer alive, sued the FBI. The case came before her, and what was interesting about her, given her sort of liberal background as a criminal defense and civil rights lawyer, and as you said, her husband's position, having been the head of the ACLU in Massachusetts, suggested to me that maybe she had some baggage in coming to preside over what would be a non-jury case. And I asked her a lot about that, and she said the thing is that judges don't necessarily have baggage. Everybody has baggage, nothing different than the rest of mankind, but they have unexamined baggage, that they haven't really looked inside themselves in terms of biases or prejudice that they bring to the table. And she's now a Harvard law professor and probably is willing to talk more about the judicial experience than others are, but she was very open and open-minded about it, recognizing that she's sort of a lot of federal judges, including friends and colleagues of mine when I was a prosecutor, are former prosecutors. Most of them aren't former criminal and aggressive criminal defense lawyers. She was. How does that impact her judging? How do other judges, how do appellate judges look at that? And she even used an expression during the course of the interview sort of suggesting, there goes Gertner again. And I said, what does that mean? And she said, well, I sort of have a persona that I'm perceived to have as this, she didn't use the word leftist, but leftist thinking judge on the court. And she was sort of talking about how well judges of her ilk would be received by appellate judges when being asked to review their cases.
Well,
so, for example, in her case, she awarded $100 million to the plaintiffs in this case against the FBI, and the judges on the Court of Appeal said she applied the law and the standards correctly, although not one of the three of us who were presiding over that case would have awarded anything near $100 million. And I asked her whether she took that as sort of a rap on the knuckles from the judges. She didn't use those words, but I think that was the sense. She said she didn't care, but that was basically the sense of what was happening.
Well, she believes that all district court judges should, as a requirement, should have experience both as a prosecutor and as a defense lawyer, as she said in an interview. And that's, I mean, I've got experience as a prosecutor and a defense lawyer. You've got experience as a prosecutor and a defense lawyer. But yet many of these judges that you interviewed, I noticed one of your judges had never even been a trial lawyer at all, and he was selected to the bench. So where do you come down on her belief that you should have both experience as a prosecutor and a defense lawyer?
Well, I guess it's ideal. It would be hard. I mean, a lot of judges are brought onto the bench directly from the United States Attorney's Office. It's sort of hard to have a requirement of that. Obviously, United States senators who are basically recommending to the president future district judges around the country have different demographics that they'd like to fill. They want to have judges who come from different minorities, some minorities that have never previously held office on the district court or the Court of Appeals. They'd like to have people from different walks of life. There are now, more gay judges or openly gay judges on the federal courts. So there are a lot of demographics that the senators are trying and presidents are trying to fill. I don't think it's possible to demand as a requirement that judges have both criminal defense and prosecution experience, because also it's very important for a federal judge because they handle also civil cases, at least equally in number civil cases, that they should have civil experience too, and that would mean they would have to have civil experience as a plaintiff's lawyer and also civil experience as a defendant's lawyer. So it's a little unworkable, although it's probably an ideal that maybe should be handled by the demographic of who the judges are, so that you have judges from these different walks of legal experience and life on the bench.
This is Justice for All. If you've just joined us, I'm George Yates with Joel Cohen here today talking about his new book, Blindfolds Off. In this case, just briefly, I wasn't quite sure of the details of why was it necessary for the FBI, in this case presided over by some other judge, obviously in the state court case, why was it necessary for the FBI to frame these guys that later on sued and received a $100 million verdict for being wrongfully convicted? Why was it necessary for the FBI to set somebody up to actually be convicted for a murder they didn't convict? I'm sorry,
it's
a murder they didn't commit.
It's hard to understand. It obviously wasn't necessary, but it's very important in the case of FBI agents, or particularly important in those days, for them to have informants. To have high-ranking informants was basically a feather in the cap of an FBI agent. And the more they were able to, quote, make cases for the FBI agent, the better off the FBI agent would appear. Fortunately, the overwhelming number of FBI agents, law enforcement agents, are honorable and wouldn't do such a thing, but you get some bad apples, and in the case of what happened over there, obviously they had some bad apples, and the reason why the case the case was tried in state court, it was a state homicide case, and the federal agent had an informer that he basically was turning over to the state authorities in Massachusetts, and so he was involved in preparing that witness's testimony in conjunction with the state prosecutors. But to say why was it necessary, it certainly wasn't necessary. It's aberrant behavior.
And in that case, as you note in your chapter with Nancy Gertner, the knowledge that this murder was framed, and large part through false testimony, which the FBI knew about, went all the way up to J. Edgar Hoover. What evidence was there that Hoover knew about it and did nothing to stop this false conviction?
My recollection is that she said that there weren't emails in those days. There were these teletypes from the local office in Massachusetts that would have gone directly to Hoover. I don't have the specifics on, that Hoover literally sat at his desk and read those, but it was part of a very important FBI program in terms of mafia infiltration, and she had enough evidence in her mind, at least from having listened to the trial, to say that there was sufficient circumstantial evidence that Hoover knew about it.
I've noticed that several of your cases, judges, presided over cases that involved prosecutorial misconduct. We've talked about Moussaoui, and I think there was some shenanigans there by someone from the TSA, which almost caused the judge to throw out the death penalty part of it. We have prosecutorial misconduct in the prosecution of former Alaska Senator Ted Stevens. And then this Gertner case. Throughout, did you choose as part of your I mean, did you actively look for cases where there was this sort of government misconduct in the case, or just kind of show up that way, just kind of turn up that way in the course of your research?
I think I was looking for big cases where there was something controversial that the judge was doing. And what the Judge Sullivan, it was in the Senator Ted Stevens case, for example, he was literally irate at the government for its misconduct in the case, and was looking literally to hold the then Attorney General Michael Mukasey in contempt because he wasn't getting satisfaction from the line assistants who were prosecuting the case, and thought that would be a better way to accomplish it. And he literally called for an investigation of the relevant members of the Justice Department. So it was that the judge was taking it upon himself to do something way out of the ordinary. It had not been done in my experience before, and that's why I chose Judge Sullivan in the Stevens case. And also, not only because the judge was doing something out of the ordinary, but he was doing something in a very, very big case. In fact, in a case where Ted Stevens was a sitting Republican judge, where whether he continued in his seat as a result of the possibility of a conviction could have affected the demographic of the Senate as to whether they would actually have voted for or against Obamacare, because there was a one vote slippage, perhaps, or in favor of Obamacare if Stevens were off the Senate bench.
Right, and that verdict came down. This was about 1 week before the election in November of 2000, and was that the election of 2008 or 2012?
I believe so.
2008,
I think.
Yeah. Well, but Obama was elected in 2008, right? So
right.
So this would have been Obamacare was about to be. So this would have been the 2010, maybe, I guess. Okay.
Well, it would have been rolled out. In other words, it would have been in the tenure of that seating of the Senate,
right,
that it would be possible that he'd be no longer a senator and a Democrat might take his place.
Yeah, and this was just, you've been a prosecutor and a defense lawyer for many, many years. That was some pretty egregious conduct where the government in that case had some, they flat out had some statements. And for those of you out there, this isn't a lawyer show. This is for people that, are interested in law topics. You don't have to be a lawyer to understand this. But, it's pretty clear that the government has a duty under the case is called Brady versus Maryland. And it was decided many years ago that says that the government's supposed to do justice in the case. And if they have information that tends to exculpate the defendant, which is favorable to their case, they have a duty to turn it over to the defense lawyers. And that's just well known. And when I was a prosecutor, I was just worried that I was much more concerned about making sure that it was fair. I would just say, here, take a look at my file. I don't want to make sure there's anything in here that's going to, be exculpatory. But more and more, prosecutors tend to hold on to this information and don't turn it over. In that case, they held on to information that they had to turn over to Stevens' lawyer, who's Brendan Sullivan, one of the best lawyers in the country, and he was unable to Ted Stevens was convicted about a week before the election, wasn't he?
That's right.
And had he had that information, had Brendan Sullivan had that kind of exculpatory information months earlier when he should have had it, would there have been a different result in the Stevens case, you think?
I think there's a big chance of it. Basically, the government was sitting on to the last minute possible a document which undermined the testimony of the principal witness against Stevens. And it was a document, it's a little complicated to go into now, but there was a document that basically would have suggested that the testimony that was being given wasn't truthful. And the government had it, didn't turn it over until the last minute, and it's a document that should have been given at the very least before the trial and probably long before the trial. And it made Judge Sullivan apoplectic about that.
Now,
and he showed it.
Now, Judge Sullivan is an African American.
He is.
And he was your only black judge on the panel that you interviewed?
Yes.
Since we're talking about diversity earlier, Nancy
Right.
Gertner said, you wanted to get a Southern judge. So you had one black judge and you had two females, and the rest were white men.
No, Judge Chin is Asian.
Okay, right. Okay, an Asian, right? And one gay judge, Vaughn Walker from San Francisco.
Correct.
So you got some diversity in there.
And I had one nonagenarian. Judge Weinstein is now 93.
Now, that's fascinating. My dad's 90. He's been on my show a couple of times because he's a retired admiral, and I've had him on just because he's got some fascinating stories going. These guys that are 93, they go all the way back to World War II and the Depression, and they've got stories. They've got the history. And Weinstein is still sharp as a tack at 93.
Unbelievable. You walk into his chambers and he jumps up like he's a 40-year-old.
Unbelievable.
And like you say, sharp as a tack.
That's just what a fact. And, he hates these mandatory sentencing, these mandatory sentences, doesn't he?
Absolutely. And there was a period of time when the mandatory sentences came into, when the sentencing guidelines came into effect in 1987, that he literally said, and he was, I think, already a senior judge at the time, which means he was tenured. He literally said he was not going to sit on sentencing in criminal cases. He would try the case, he would take the plea in case, but he wouldn't sit on them. And there was some hoopla. Some members of the Congress, particularly right-wing members, because he's viewed as a liberal, would say this is an outrage, he should be impeached, but to do his work. This is a guy who works tirelessly 24 hours a day, and he was willing to take any other case, but he just wasn't willing to engage in sentencing people for ridiculously draconian sentences, and that whole idea sort of passed by. But, I mean, he's really a bug about mandatory sentences, like you say, because he thinks they're ridiculous, and the people who chosen to impose mandatory sentences on the Sentencing Commission were wrong-headed in doing so.
Well, this sentencing, federal sentencing guidelines thing, it came into effect in 1987, and it was modified around, I guess, 2006 or so, the Booker decision and progeny. And I'm always fascinated when I've got guys like you that can remember trying cases in the federal system before the guidelines and before a lot of these mandatory sentences, and now afterwards. What's your general opinion on the federal sentencing guidelines? How was your take on them when they first came in, and as they worked over the years, or didn't, or failed to work?
Well, there was a good reason for the sentencing guidelines. The reason for the sentencing guidelines is, for example, say in New York City, which I'm most familiar with, you would go into federal court, the case would be wheeled out. There's literally a wheel there where they turn the wheel and a judge's name comes out. And it could be the most lenient judge in the courthouse or the most strident sentencing judge in the courthouse. And it could be the difference in those days when there were no guidelines that one judge could give the guy literally probation and the other guy down the hall could give the guy 20 years. And it was simply unfair that you were literally being sentenced by the luck of the draw. So that was the motivation for the sentencing guidelines. The problem with it was that in an effort to make them largely uniform, you were getting into a situation where the calculus that was being used to make the sentencing decisions was just far too onerous. And people were going to jail for ridiculously long periods of time for sometimes fairly trivial offenses. And where it got even worse was in the case of narcotics, where if somebody was using crack, and it was typically more so in the minority communities, the sentencing guidelines for crack were like 2-3 times what the sentencing guidelines were for cocaine, and it was just unfair till the guidelines were changed to try to accommodate it. But the problem is you'll find not only defense lawyers are unhappy with the guidelines, prosecutors are unhappy with the guidelines because it makes it difficult for them to get guilty pleas, from defendants, and judges are particularly unhappy with it because they are put in a position of having to impose draconian sentences that they don't think are warranted.
Well, and the mandatory guidelines back when they first started, it was almost impossible for a judge to find a reason to deviate downward from the guidelines, wasn't it?
Right.
And now they can deviate downward if they've got a reason. So judges can go back to judging a little bit, but there's much more uniformity now than there was before the guidelines. But judges can go back to judging. Is that a fair statement now? They can actually go down a little bit, or
more so. It's still obviously not a home run in terms of being able to get out of the guidelines, but it's a lot better than it was.
A lot better than it was. And it's still a bit of a wheel now, isn't there? It's still like I just know in my courthouse that you got a certain kind of case and hasn't really been assigned yet, and then it gets assigned, and you know you've got a certain judge, and now you're sitting down with the U.S. attorney, and he's saying, well, this is our judge, so I think we got a pretty good idea what he's going to do, and it's going to be better than what you would have had, let's say, if you'd had this judge or that other judge over there. So there's still a little bit of forum shopping, although you can't shop. And you discussed that with one of your judges. Was that Feldman you discussed whether or not people do judge shopping or forum shopping?
I did discuss that with him. There used to be a situation where, I think it was in California, where defendants were able, as in the case of juries, to exercise a peremptory challenge, so that if they didn't like a particular juror, they could literally throw them off with no questions asked. It's not as common anymore for a lot of constitutional reasons, but I think it used to be the position in California that if you were assigned to a particular judge, you could issue a peremptory challenge to the judge, which was a form of forum shopping. Judge Feldman was against that, and I frankly think I'm against it too, because I think it's probably inappropriate. But
if you've just joined us, this is Justice for All. I'm your host, George Yates, and I'm here with Joel Cohen. He's a litigator from New York City. He's the author of Blindfold's Off. It's a new book out on judges and how they decide. And Mr. Cohen went out and interviewed 13 top federal judges around the country on how they decide cases. We've just got a couple more minutes before the break, Joel. In general, I noticed that with David Hittner, one of your judges, this was a great case involving what I got out of your interview with him is how he really got quite a bit involved in trying to get parties to settle. Were you a little bit surprised by how involved he got with trying to get parties to settle a case as opposed to try it?
Not really. It was a case involving some buildings in the community that had sort of become an eyesore and had been run down. And they wanted to basically tear down the community, but there were folks who were staying there and weren't willing to leave and whatnot, and there were proceedings brought to try to remove them. And I think Judge Hittner recognized that you're basically taking somebody out of their home, and that's pretty imposing to do. And what he was hoping that by giving them time and giving them an effort to talk with each other and have community folks sort of persuade the dissidents to ultimately leave and they might be able to find a better home, he felt rather than just uprooting them with a court order, he rather wanted to even delay it if possible to get them to come to terms with it on their own. I thought it was sort of a wise way to proceed. It's sort of frustrating for litigators sometimes that a case drags on like that happened, but I think he sort of had his eyes wide open on it, although he made very clear, and I had never known Judge Hittner before that he's probably a guy you didn't want to mess with. Once he made up his mind and said, I got to get these people out of these homes and out of this location because it's unsafe or impractical, I don't think he was going to have any reluctance to bring the full majesty of the law behind his edict, and they would be removed. And I think they probably recognized that.
Yeah, I was impressed with Judge Hittner's interview quite a bit. We're going to be right back for our last 30 minutes with Joel Cohen. We're going to take a break here. I'm George Yates, and this is Justice for All. We'll be right back.
Authentic Indian Cuisine have a party hall and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at India.
Well, we're back. This is Justice for All, and I'm George Yates. If you've just joined us, I'm with Joel Cohen, and he's just written a great new book called Blindfolds Off, Judges on How They Decide. And, it's an inside baseball kind of book about how judges decide cases, and Joel tried to, Mr. Cohen here tried to basically get in. He interviewed these judges for an hour and a half, each judge. Basically up front and personal on how they make decisions. And one of the most interesting chapters in his book is where he interviews Vaughn Walker, who was the first, he wasn't openly gay at the time he was a judge. He didn't actually come out until after he retired from the bench, right, Joel? But I think everybody in the San Francisco area knew he was gay. They just didn't really, it just wasn't an open kind of thing, was it?
I think that's right. He even says in the interview, all my colleagues, certainly, it was a question about his colleagues. He says everybody knew that I was gay, unless they were just totally out of it. He wasn't walking around saying I'm gay, but it was pretty clear that the legal community knew it.
And he was a Reagan appointee, right? Or Bush?
That's right. Well, he was first nominated by Reagan, and then he was actually was stalled or killed, because the perception of it was, and it had not been made public that he was gay yet, the perception was that he had represented the United States Olympic Committee in a litigation against the Gay Olympics for a copyright violation. In other words, he was representing the non-gay side of the litigation, and the view was that he had taken a very aggressive stance in his litigation against the Gay Olympics. And some of the liberals in the Congress, including Nancy Pelosi, who wasn't yet Speaker of the House, she had said that the president ought to hold up the nomination because this guy appeared to be anti-gay, which is kind of interesting, given what later happened.
To say the least.
And what later happened was when the lawsuit was brought in opposition to Proposition 8 by David Boies and Ted Olson, who were 2 great lawyers in the United States, the case was wheeled out to Judge Walker. And the proponents of Prop 8, which were against same-sex marriage, had the full opportunity, because they knew it, to seek to disqualify Judge Walker. Not that I think that such a motion would have been meritorious. They could have done so, and they didn't so. And Judge Walker says the word sort of came back to him that he was not going, that they were not going to raise the issue at all. So anyway, the case is tried before Judge Walker. There was a full-blown trial of the evidence. David Boies apparently made mincemeat of some of the Prop 8 expert witnesses, the result of which is Judge Walker ruled against the constitutionality of Proposition 8, and then sometime later retired from the bench, having nothing to do with his ruling in the case. The case then came before another judge, and the Proposition 8 proponents said that Judge Walker should have recused himself, or at least made public the fact that he was gay so that they could make a recusal motion based on that. And the case came before, I forget his name, a black judge sitting in the federal court in San Francisco. And he said, you're saying that Judge Walker couldn't sit on the case because he's gay? Are you saying that I can't sit on a civil rights case because I'm black? And that was pretty much the end of that argument. And they lost it, I believe, in the Court of Appeals as well. So the interview with Judge... I'm sorry?
Well, go ahead.
So the interview that I was conducting of Judge Walker, as I said to him right at the beginning, would be somewhat invasive because I'd be asking questions about his status as a gay and how that would have subtly or not so subtly impacted his decision-making in the case. And at some point, I was sort of pushing him a little to try and find out what was his mindset in certain decision-making that he did or didn't make. And I literally said to him, "But you understand, Judge, I'm trying to get inside your head." And he said, "Yeah, Joel, but you know there's only room for one of us in there." And that was as bold a statement as any of the judges had made during the course of the interviews for this book, basically saying, you know what, the way I took it, I'm willing to go so far. There are some things you may want to inquire about, but I'm holding my own on that, and I'm not allowing you to go that far. That's sort of the way I took it with Judge Walker. I thought he was perfectly within his rights in doing that, but it was sort of a statement to say, that's as far as we're going with that.
Well, now, Judge, one of your other judges in the book made a comment. It says, you always have to struggle to escape your own point of view. And I wrote that down when I was reading your book. You always have to struggle to escape your own point of view. And so when you're interviewing Yvonne Walker about a gay rights case, then he basically told you in the interview that he could escape his own point of view. He even said that he could have, as a lawyer, represented the people that were arguing against Proposition 8. So
that was extraordinary for me to hear. I remember that vividly. I could almost see it in my mind's eye that moment back in San Francisco when that conversation happened. And it was astounding to me when he said that, and I expect that it will probably astound a lot of readers as it apparently has you.
Yeah, because a lot of people think, well, you know, this lawyer wants to take this case or this particular case because, you know, the practice of law is a noble profession and we want to fight the good fight. And, you know, that's what advocacy is about. That's why we went to law school and that sort of thing. And then, you know, basically you're hearing from this judge, well, you're really just nothing more than a shill, and you're a lawyer and you've been hired to do a job and that's your job and you go out and do it. And it kind of, I'm not quite sure whether I believed that, but I know that's what he said. I'm not quite sure that, but moving on from that, I thought that more on the Von Walker matter, just as the state of gay marriage. I know that in Virginia here we had a federal judge that Arenda Allen, who ruled that the Virginia scheme against gay marriage is unconstitutional. So that's, and the Fourth Circuit affirmed her. So that's ripe for the United States Supreme Court to take up. I know there's been activity all over the country. Proposition 8 is the California law that came out basically and said that gay marriage was illegal, correct?
Right.
And so Von Walker declared that was unconstitutional.
And that's the case that actually went to the Supreme Court. The Supreme Court didn't decide it on the merits. They decided that the people who supported Prop 8, because the governor wouldn't support it, the people who supported it didn't have standing, and that's why the Supreme Court basically affirmed Judge Walker's ruling. But that's the case that went to the Supreme Court, and presumably it's going to go to the Supreme Court in another case this term.
Yeah, what is the status of the gay marriage initiative all around the country right now, as far as you know?
Like a whole bunch of judges around the country, and some circuits have affirmed the right to gay marriage. I think now that the Supreme Court is being asked to consider it again by opponents of same-sex marriage, that the gay rights movement is actually asking the Supreme Court to decide the case on the merits, even though they've won it in a lot of jurisdictions around the country, because they wanted the case decided once and for all.
Well, what is the standing issue for people out there? That what is there a standing issue now? I mean, if somebody wants to challenge a law, or how is the Supreme Court going to take it up in such a way that standing's not a problem?
Well, I think it's hard. For example, recently, Judge Jones, who's one of the other judges in the book, he, although this wasn't the case we discussed in the book, he declared the ban on same-sex marriage in Pennsylvania unconstitutional. The governor announced a few days later that he was not going to appeal Judge Jones' ruling on behalf of the state. In other words, to try to reinstate the statute banning gay marriage. As a result of it, as I understand it, and what the Supreme Court said in the case that Judge Walker had, is private parties or private groups don't have a right to litigate the case in the courts. Only the government can seek to sustain the constitutionality of a law. That's why in California, since Governor Schwarzenegger wasn't willing to litigate the case in support of the ban on gay marriage in California, nobody else could. So what they would require is either a state where, as I understand it, and I'm certainly not an expert on this area, a state where the government of the state supports the ban on gay marriage. If that government or that governor were to litigate the case, then there would be sufficient legal standing in the courts for the case to go higher up.
Yeah, and in Prop 8, I think that Jerry Brown was governor at the time, and he refused to try to enforce
it. Right, it was started off at Schwarzenegger, and Jerry Brown was later the governor, and he would not support it.
Now, Vaughn Walker told you in the interview, and if you've just joined us, I'm with Joel Cohen, author of Blindfolds Off. Vaughn Walker told you that he entered into this litigation with an open mind, and he was just waiting to hear from the opponents of Prop 8 as to why gay marriage was a bad thing, right? I mean, he told you, well, he said he was prepared to listen, but they just didn't make their case, right?
That's what he said.
Did you believe him?
That's what he said.
Well,
I don't want to say I didn't believe it. I don't want to leave that impression
Sure.
to your listeners.
Sure.
It's hard for me to believe that. It seems like almost a superhuman feat under the circumstances. But the interesting thing is that in the foreword to the book, Judge Posner, who is a very widely known and controversial judge who sits on the Seventh Circuit Court of Appeals in Chicago, says that the problem with the interview method of judges is that they're either guarded or unself-aware. I do believe that Judge Walker believes that he came there with an open mind. It's a very tough mental gymnastic under the circumstances for him to have done so, but I certainly believe he believes that and believed it when he said it.
What else is there about Vaughn Walker that struck you besides what we've already discussed?
He's a very elegant guy, a no-nonsense guy. I think when you walk into he's, by the way, if you used to watch old Perry Mason episodes, he's exactly what a judge would typically look like. I'm sure when you're in his courtroom, you know who's the boss there. That was certainly the sense of it. He was very cautious in his words. He didn't say anything without thinking through it. You would see others that I spoke to it would come out of their mouth as soon as they had something they had to say, and they didn't carefully think through the analysis of what they were saying. My sense of him was he was very cautious, very careful, and extremely articulate.
My favorite judge, I'm not sure which one was my favorite, but I think that my favorite was probably Alex Kozinski. He's born in Romania, grew up in his early years under a communist government, and then moved to the United States with his family, and brought a real sense of his humble origins to his sense of judging, and he made a comment which I've noted in your interview with him, where he says, once they go after the poor people and get them, the rest of us are not far behind. And I thought, coming from a federal judge, that was quite a profound statement. Anyway, I want you to tell us a little bit about this fascinating jurist.
Well, what's really interesting about him is he's a libertarian, which to my mind is closer in the spectrum of things to a conservative. And I asked him at the outset, and like you said, he was born in Romania, and he admits that that had a tremendous impact in terms of his judging, in terms of his view of Big Brotherism. He basically said pretty much from the outset that his judging is, he left my jaw dropped open when he said this. The case I asked him about, because he had made a statement in an opinion where the Drug Enforcement Administration was putting some kind of a GPS device under a car, and the goal of it was to find out if that guy whose car it was engaging in narcotics trafficking, and it was really marijuana. And the guy was sort of a poor guy, but a marijuana trafficker, and they put the device under his car within an area where he lived in a trailer park. So his car was in a trailer park, and under the cover of night, the Drug Enforcement Administration put the GPS device under his car. And he was horribly offended that they did that, saying if basically a guy had a BMW or a Mercedes in his driveway, judges might be more concerned about the violation of privacy by them going in under cloak of night and doing that. But they weren't so bothered by a guy going into what the law calls the curtilage, which is the general area of the guy's home in a trailer park. And he said in his opinion that judges suffer from an unself-conscious cultural elitism. I didn't know exactly what that meant, but obviously they weren't paying that much attention to the rights of poor people. And I asked him about that. And I said, why'd you get so interested in this case? This case involved marijuana. I mean, marijuana, a lot of marijuana, but it's marijuana. It wasn't heroin and whatnot. He says, I actually didn't even remember it was marijuana. I was concerned about what the government was doing in this case, but I was not so much concerned about the rights of Pinedo Moreno, who was the defendant in the case. I was interested in what writing I would do in this decision or dissent that he wrote that might impact other defendants or the law in general. So I said, Judge, you're saying basically you don't really care so much about this case. You're caring about the value that it could have for other cases? He said, yeah. I was interested in what could happen if the case went to the Supreme Court. I was interested in what the other judges in the Ninth Circuit where he sits might say about it, or what judges might say all around the country, because I could have some impact on judging generally by my decision-making. And again, as I said before, my jaw dropped open. I said, Judge, most people sitting in my side of the table in your chambers would think that judges write a decision, issue their opinions, do their workmanship as judges in order to basically decide a case. And you're telling me you're not so interested in this case. You're interested in the law generally. And he said, that's right.
Well,
so
when you ask, and what bothered him so much was the fact that the rich guy, the rich people which most federal judges are wealthy people. And I think he was struck by the fact that not too many poor people get appointed federal judge. And so the federal judge is generally going to be somebody from the wealthier side of the street. He's going to be able to park his BMW away from the street. The FBI is not going to come in there and put a GPS on his car. But the poor guy living in the trailer park, who has just as much of a right to privacy as the rich guy, and the police don't have any problem in walking up there and putting a GPS on his car. And it just outraged him that the poor person is not entitled to the same rights, the constitutional rights and right to privacy, as the wealthy person. And that's what I guess when I say he was one of my favorite people that you interviewed. You know, I mean, the name of my show is Justice for All, and a lot of times I do take maybe a little liberal bent sometimes because I think that the little guy ought to get his fair shake too, and I think that's what Kaczynski came across as. He wanted everybody in the country to know that he thought that the poor people had the same right to privacy as the rich people did.
He certainly did, and even more important in some way, he had no bones about saying exactly what is on his mind. I mean, he was willing to say, hey, I'm trying to push around, not push around in a bad sense, but I'm trying to move the federal and state judiciary in ways that I'm able to from my bully pulpit. And actually the chapter is referring to a bully pulpit, that he had a bully pulpit as basically the chief judge of the Ninth Circuit, which is a very big deal in the federal judiciary given the many states that are included within the Ninth Circuit and the population of that circuit.
Well, yeah, and the Ninth Circuit is the circuit that encompasses California, right? And wasn't that that used to be more of a liberal court, and it's taken on a more conservative bent in the last few years, and I think that's where Kaczynski's coming from, right? I mean, I think he's wanting to move the court maybe in another direction from where it's been.
Yeah, I don't think he has the capacity to move because there are so many judges, and he only sits on some of the panels.
Right, exactly.
But would he like to move the court in that direction? For sure, he would.
Yeah, and
he actually clerked for Judge Berger on the Supreme Court of the United States.
Well, right, and he wasn't he a Republican appointee as well?
Correct.
You know, and I think that this is pervasive throughout your book. It's fascinating, and I think what do you have to say about that, Joel? That you know, these judges are not so easy to figure and pigeonhole. You want to say a Republican appoints them or a Democrat appoints them, but they don't always turn out like you think they're going to turn out, do they?
Well, yeah, the classic case in that book is Judge Jones. John Jones was a Republican. He was recommended for his judgeship by Rick Santorum of the United States Senate, conservative from Pennsylvania, who actually ran for the nomination for president. And he basically, Santorum would have been, no doubt, of the view that intelligent design should be allowed to be taught in the schools. And notwithstanding where Jones, for lack of a better word, came from, Judge Jones decided against it in a very strident opinion against intelligent design. And Bill O'Reilly and Phyllis Schlafly, a conservative lobbyist, took the position like, how could Jones did this? We are the people who put him on the bench. And he said, as I recall it, the United States Senate confirmed my nomination of the President of the United States to the bench, and I'm obliged to do what I think the law is, not what people who supported me think the law is. And he was criticized roundly by the right for having done so, and it hasn't stopped him because, like I said, he just decided the same-sex marriage case in Pennsylvania in favor of same-sex marriage, which would also obviously not be within the political views of Santorum and some of his followers.
Yeah, I'm sure that was a real shock to Santorum to find out that his appointee just didn't go his way. But I think that's refreshing to hear that.
Absolutely.
I know. Well, is there a particular judge? We only have a few minutes left. I noticed that we've got one judge, your Quinones case. What was fascinating about him was he declared the death statute unconstitutional because he found that the role of DNA, and with all these exonerations, and I was fascinated by this, he made a comment during your interview where he says, you know, the system as we have known it is way less accurate than prosecutors and lawyers have believed. He was quoting Alan Dershowitz in his book, The Best Defense, as saying that, you know, virtually all of these defendants that come before the bar are guilty. And now he discovers that, wait a minute, there are so many people that are found guilty, not only proof beyond a reasonable doubt, proof beyond all doubt in some people's opinion, sentenced to death. And I had a fellow on my show not that long ago that spent 21 years on death row in Pennsylvania and was exonerated by DNA evidence. So he was a fascinating character. He was, of course, overruled. He declared the death penalty unconstitutional, and then it came back to him, and he tried the case. So What is your thought on? Do you agree with his proposition that the system is way less accurate than prosecutors and lawyers have believed?
Well, he said something that was intriguing. He said he had been a prosecutor. He was the chief of the securities unit in the Southern District of New York. He said, when I was a prosecutor, I believed, as do I, Joel Cohen, believe, and you probably believe, that we always got the right guy, that everybody we were prosecuting were guilty. And I came to believe that the system works, that people aren't prosecuted unless they're guilty. And I've come to learn, he says, as a result of the Innocence Project and the great work that my friend Barry Scheck has done to find people who were truly innocent years after they were on death row or in life in jail and whatnot. And he says, we can't take the chance. I said, well, and I asked Judge Rakoff, but you got on the bench. You knew nothing about this case. You knew nothing about the guilt of this case, and it wasn't a particularly, it was a heinous murder, but it wasn't, something particularly in the public view that he decided to ask the lawyers to litigate immediately the issue of the death penalty before he had any reason to believe that the defendant, Quinones, was not guilty. I said, why are you doing it? He said, I thought about it a lot, and I thought that was the appropriate thing to do. And if they were going to litigate it, let them litigate it as best as they can right now. If the Court of Appeals says I'm wrong, the Court of Appeals says I'm wrong. I said, it's pretty easy, Judge Rakoff, for you to declare the death penalty unconstitutional in the Quinones case. The public barely even knows about that defendant. Some of the tabloids might have covered it because it was a heinous killing of a police informant. I said, but I'm looking out your window right now, and one can see from there where the World Trade Center used to stand. Let's assume that Osama bin Laden had actually been captured and brought back to the United States to face the death penalty for 9/11. Are you telling me, Judge Rakoff, that you would have declared the death penalty unconstitutional in that case? And he didn't hesitate for a moment. If you're doing the job right, that's what I should have done. That if those facts had occurred, who knows if I would have been brave enough to do that? But it was my duty to declare the death penalty unconstitutional in that case, just as in this case. What was also kind of revealing about Judge Rakoff is he revealed that his own brother had been murdered in the Philippines years before. And I said, does that impact your view of the death penalty, that your own brother had been murdered and his killer gotten off with a fairly lenient sentence? And he sort of froze for a minute and ultimately said, I would try to apply the law the same way, and it shouldn't have an impact. But who knows? At the end of the day, I'm a human being just like everybody else. And it was kind of a very touching moment in my experience with him.
Well, and we're going to have to leave it there. We've only got another minute or two left. I just wanted to say that Judge Rakoff did, when he, in that case that came back to him, they did not impose the death penalty, right? And so when he made his final comments in the case, he did reach out to the victims and shared that experience, which he said he'd never share with anyone else beside his own family members.
That's right.
My guest here today has been Joel Cohen. Thank you so much for being with us today, Joel. It's a real thrill to have you on the show. It's a great book. I had a great time reading it. And for those of you out there that have not had a chance to listen to the entire interview, you can go onto our YouTube site, Justice for All with George Yates, or go to my website at www.ghylaw.com and hear the entire interview. We'll have it uploaded at some point. So I'm going to say adios to Joel Cohen. Thank you so much for being on the show, Joel.
Pleasure. Thank you so much for having me.
Okay, great. And we'll see you again next week from 2 to 4 on Justice for All here. And you have a great afternoon, everybody. Goodbye.